We are joined now by Ms. Atulu Babalaya, who is a legal practitioner. As we turn our attention now to the NDLEA and the Kashama matter, has been on for a while now. So let's go ahead and thank you for coming on first and foremost today. You've been following this matter. We did ask the IGP just now about what his men are doing about it, because we read the court gives a certain judgment, there's a response from the NDLEA, and it looks as though almost everyone wants to have a comment or two about this one. But is there anything that the NDLEA has done wrong here? Because they say no, this judgment is not as people are interpreting it, that they are there to do a legal job.
Well, thank you very much. I wish to inform all Nigerians that NDLEA is just deliberately causing confusion.
How?
They bugged this case right from day one. I want to refresh the memory of Nigerians that the case that was given, which judgment was given yesterday, is not the beginning of this process. There was a case in which the judgment was given as far back as 2013, in which NDLEA was a party. And in that case, I want to reach a part of the judgment to you, where the court said that the affidavit of NDLEA is worthless. Let me just read a part of the judgment to you. The judge said, having gone through the counter affidavit of the fourth respondent is the NDLEA, I have been wondering whether it should be really be referred to as a counter affidavit. This is so because the positions therein do not challenge the applicant's affidavit. Applicant now is the Kashamu Buruji. In support of the application, the deposition therein, in fact, support the claim of the applicant. I will return to the issue later in this judgment. The learned judge also referred to the issue later in the judgment. I would let Nigerians know. The judge was reading the affidavit of NDLEA in this matter. Paragraph 10 states that as at October 1999, a list of all Nigerians requested for extradition or against whom there were provisional arrest warrant by the United States of America authorities were made available to the fourth defendant, which is NDLEA. Attached here thereto is a list of the said person attached as a exhibit NDLEA 1. It further goes that upon a look at the list, the name of the applicant was not in the said list. This is NDLEA. NDLEA also, further deposed that all through the period of 1999 to 2002, no request for any person by the name Buruji Kashamu was made to the fourth respondent by the USA authority. Also, the Inspector General of Police that had just left this place has since long ago cleared Kashamu Buruji. He is also in this judgment. By the fourth respondent, which has not been challenged, excuse me, please. The Interpol investigated this man.
Not this IGP.
The IGP also was involved. There's no way Interpol can come to Nigeria without a
No, what Chamberlain is asking is not this present IGP.
IGP is an office.
No.
Yeah, not this present one.
We want to say the office.
Okay, the office of
because
the
when you
Inspector
said
General
that
of
just
Police.
left, that you're talking about.
Okay, I'm sorry. I am referring to him as the person
office.
holding the office.
Okay.
Thank you very much. Then he said, with the file placed before me by the parties, I think the petitioner were really unfair to the applicant, with outrageous violent words used in the malicious petition. Against, as far back as 2008, the applicant had already been investigated by the International Criminal Police, Interpol.
Okay. All right.
Of all the allegations contained in the petition and was cleared by the report exonerated him. The report is exhibited in BK9 attached to the applicant affidavit. Top paragraph at page 6 of the exhibit EK9 duly issued by the first respondent.
All right.
First respondent is the IGP.
Okay, we lost one of those calls there because we're actually trying to get the spokesperson for the NDLEA, Michel Afoyeju, via phone, as well as the counsel to Buruji, Kashama Jibola Oluyede. But it looks as though we've lost one of them. But what we'll do is we'll just take a moment and get those connections back, and then we'll get both of them to get their response on this one. But could you just go ahead with that?
Thank you very much. of what the allegations contained in the petition and was cleared by the report exonerating him. The report is attached as BK now, attached by the applicant's affidavit. Third paragraph of at page 6 of Exhibit EK duly issued by the first respondent. First respondent is the IGP, which was not challenged. The first respondent stated that all our letters, first respondent now is the Inspector General of Police of Nigeria. He stated in the affidavit that all our letters written to Interpol London, Lyon, Washington, and Cotonou relating to the inquiries on criminal drug conviction record of the suspect were returned negative to the effect that the suspect was never committed
Mr. Babaloye,
any offense.
The thing is, why will the NDLEA deliberately want to do the wrong things? It doesn't make any sense, does it?
Honestly, it does not make any sense, and that is why we are saying the right thing be done. NDLEA,
What's the right thing?
the right thing, my brother, if you want to exonerate and extradite a Nigerian, there is an extant law, Extradition Act 2004, as amended by Extradition Act of 2014, stipulated what and what could be done. And when you look at the Extradition Act of Nigeria, it talks about extraditing a Nigerian to Commonwealth countries. And by implication, America is not a Commonwealth country. And America and Nigeria has no any functioning treaty on extradition.
The last time we spoke with Mr. Foyeju, although it was off the air, and we also heard him on the air say they're not arresting him with a view to extraditing him, that he was supposed to just go to the court and face the charges, having lost his case in court.
My brother, they cannot do that one because it will be unconstitutional. This man has been cleared by 2 courts in UK in respect of the same offense. Nigerian court has also cleared him with 2 judgments. And there is a principle we call ultra force acute in Nigeria under the section 35 of the 19th Constitution. When a citizen has been cleared, he has been taken to court and is acquitted, you cannot revisit that crime.
But you read the reports in several papers here, how former president did send some documents to the outgoing president about the same matter and how he's wanted in the US.
Well, that is the thing. He may be wanted in the US, he may be wanted in anywhere. But what we are talking about is that there must be due process.
Is he wanted in the US?
Well, the US people are saying he's wanted. If you follow the proceeding very well, the US even came to UK to request his extradition from UK. UK court subjected him to extradition proceedings, and they found out that there was a case of mistake of identity. They could not state whether it is actually the person they are looking for or not.